Hey guys, today I'm going to talk about Order 13 Default Judgment. Some of you may have watched the earlier video I did on Order 14 Summary Judgment. Now, summary judgment is different from default judgment. Under Order 14 Summary Judgment, a defense is actually filed with the court, but the plaintiff applies for summary judgment. That means quick judgment, because the defense, there's no real defense. It is essentially a BS defense. Now, Order 13 default judgment is different. Default judgment means that you do not enter an appearance within 8 days. As you can see over here, this is a sample writ of summons. As you can see, it says that you must enter an appearance within 8 days, otherwise the plaintiff can enter default judgment against you. For default judgments, all the allegations in the statement of claim are deemed to be admitted. Therefore, if a plaintiff ignores the writ of summons, he for some reason he doesn't want to respond to it, he throws it away, or he can't afford a lawyer, the plaintiff can apply for a request to enter judgment, okay? Provided that a memorandum of service has been filed, okay, under Order 10 Rule 1. Default judgment cannot be entered unless a request to enter judgment in Form 79A is filled together with the judgment in Form 79. The purpose of this is that you have to prove that the writ of summons was actually served. For a liquidated sum, that means a fixed sum of money that you are claiming, for example, $40,000. What you do for the default judgment is that you state the liquidated amount, and then the interest will be calculated at 5.33% per annum, and costs will be awarded according to the rules of court. To qualify as a liquidated amount, the amount must either be already ascertained or capable of being ascertained as a mere matter of arithmetic. Depending on the nature of the claim, the judgment may be final or interlocutory, or partly final and partly interlocutory. Interlocutory means interim, depending on the nature of the claim. A judgment is referred to as interlocutory when further steps need to be taken to finalize it. For instance, the court may give an interlocutory judgment for unliquidated damages. That means damages to be assessed. It's not a fixed amount. The court has to assess the amount of damages payable to the plaintiff. Such an interlocutory judgment will only be finalized upon the assessment of those damages under Order 37 of the Rules of Court. An interlocutory judgment may also be obtained where the claim concerns the detention of goods. That means detinue, you hold on to goods that do not belong to you. Or where there is a combination of a claim for unliquidated damages, that means unascertained damages, and a claim in relation to detention of goods. Sometimes it's not because the defendant ignored the writ of summons, but the defendant did not have a look at the defendant did not see the writ of summons because he was overseas. Or sometimes even the plaintiff solicitors, if they obtain an order for substituted service, that means to paste the writ of summons on the door, the plaintiff solicitors could have pasted the writ of summons on an old address or a wrong address. I've came across several defendants who did not receive the writ of summons because the lawyers pasted the writ of summons on the old address. And so under such circumstances, the rules allow a defendant to set aside, that means cancel the default judgment. The rules of court specifically provide for the setting aside or cancellation of a default judgment, because the principle is that such a judgment is not given on the merits of the case. That means it's not based on evidence, but rather the default judgment is entered because of the defendant's failure to take the necessary procedural steps. That means, in other words, to enter an appearance within 8 days of service of the writ. So, Order 13, Rule 8 merely empowers the court to set aside a judgment entered in default of appearance. The application is usually made by summons supported by an affidavit giving reasons why the default judgment should be set aside. So thanks for watching this video on Order 13, Default Judgment.